So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
Fighting words from Bryan Kohberger's lawyer, Ann Taylor. She's accusing the FBI and the prosecution of hiding evidence from her team.
To be clear, the state has nothing to hide.
And the prosecution is firing back at a recent claim by the defense about where Bryan Kohberger says he was the night 4 University of Idaho students were murdered. Thanks for joining me for Crime Fix. I'm Angenette Levy. For a while, things appeared to be pretty cordial between the prosecution and the defense in Bryan Kohberger's case, but things have become pretty heated lately. It seemed to go south during the fight over the defense conducting a juror survey, which they're still allowed to do after a big court fight. Now there's a big conflict over whether an upcoming hearing should be closed to the public. The prosecution wants the hearing sealed or closed, meaning only attorneys and court staff can attend, no members of the public, and certainly no members of the media. There's information that Bryan Kohberger's defense team believes they're entitled to, and they haven't received it. And what exactly that might be kind of remains a mystery because everything related to discovery in this case is filed under seal. But Ann Taylor dropped a few hints. More on that in a minute. But first, Ashley Jennings, an assistant prosecutor for Latah County, argued about why she believes an upcoming hearing should be closed. Take a listen.
So, Judge, the applicable authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124. Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing. Feel confident that when the court does this same balancing test, it'll come to the same conclusion.
Jennings says the information that would be discussed in this upcoming hearing was discussed in a motion that was originally filed under seal, so the public couldn't see it. Now the defense wants it discussed in public.
Now the defense is taking a contradictory position and asking the court to ignore all the previous filings, and this is just entirely inconsistent. To be clear, the state has nothing to hide. However, it's crucial that we protect, as we have been trying, the integrity of this case, and that we protect, ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial.
So Ashley Jennings kind of has a point there. It does seem inconsistent. Here's Ann Taylor's response to that.
It's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we filed those under seal for expediency in saying this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we filed those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law.
You're going to get no argument from me when it comes to keeping courtrooms open to the public. I've been covering courts for a really long time, and closing courtrooms in criminal cases is really rare. It really doesn't happen often. It should be done out in the open, the court's business. But the defense kind of brought this on themselves to a degree. They didn't even want cameras in the courtroom. They've agreed to file things under seal. And now they want things out in the open again. And I'm all for that. The prosecution had this to say about what could happen if the hearing were to be open to the public.
If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions, and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that.
So this probably has you wondering, what is this information and why is it so important? Well, some of it has to do with video from the area of the King Road house on the night of the murders.
Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye.
Remember, that video is really important because originally the FBI analyst said the car was a white Hyundai Elantra and it was a model made between the years of 2011 and 2013. But the probable cause affidavit said that changed. The analyst went back and looked again and decided that model could have been made between 2011 and 2016. Kohberger drove a 2015 Hyundai Elantra.
Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public.
There's also other information the defense wants related to cell tower records.
But that order was to protect information, the IGG information, that they say details how the state got to Bryan in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear?
One of the things that Ann Taylor wants is the FBI's CAST report. I spoke with retired FBI agent and attorney Bobby Chacon about the CAST report and what that is.
Yeah, the CAST is the Cellular Analysis Survey Team, and that report would be the data of Kohberger's cell phone movements that the FBI provided that assistance to Idaho for this case. It is an interesting situation because the FBI is not a party to this process. They're not a party to this proceeding. So they're not in court at these hearings. So it's almost like the court either has to compel the FBI to come in and provide that or compel the state to get it from the FBI. And I would assume that's what the defense is going to try for, to have the court compel the state to get it from the FBI, whatever it is that they want. Or they can, I guess they could subpoena the FBI into court, the FBI agents into court to provide that information or testimony about it. But I think that CAST in recent years has claimed to have technology that can greatly increase the accuracy of cell phone triangulation data, much more accurate than was previously done in the past. That actually, though, is subject to some controversy. There are some experts in that field that push back on the FBI's claims that of how accurate that can actually be.
Now, as we know, the prosecution is relying heavily on cell phone information in this case, and so is the defense.
Absolutely. Because not only is it a big part of his alibi, but it's also a big part of the prosecution's claims that he was at that house not only on the night of the murder, but maybe on previous occasions as well. So I think that cell phone data is going to be a huge piece of the evidence in this case, both for the defense and for the prosecution. So, for his alibi and for their theory of the case that he was in that area, again, on the night of the murder and previously. So I think that there, you have the DNA on the knife sheath, you have the witness that was left alive in the house, and you have the cell phone data. Those are the three big pillars here, I believe. And so I think that cell phone data is definitely going to be heavily contested, both in these pretrial motions and hearings and at the trial in front of a jury. I think you're going to have a lot of expert testimony come in. It's going to be kind of a battle of the cell phone experts in this case.
I want to take a short break from this update on Bryan Kohberger's case to tell you about something that can help you learn more about the people in your life. It's a great website, and it's called truthfinder.com. Truthfinder is one of the world's largest public records search services. Truthfinder has one goal, and that's to help you and me learn the truth about the people we meet each day. Here's how it works. Simply log on to truthfinder.com and put in a name. Within minutes, maybe even seconds, you will get reports that include phone numbers, addresses, friends and family members, criminal records, and much more. It will also show you sex offender statuses for people who might live in your neighborhood. The cases that I cover each day make it clear that you have to do everything you can do to keep you and your loved ones safe. So right now, Crime Fix viewers can get 50% off of confidential background reports. Just log on to truthfinder.com/LCCrimeFix and start accessing information about almost anyone. That's truthfinder.com/LCCrimeFix. The defense has already said it will call an expert, Cy Ray, a retired police officer, to testify about Bryan Kohberger's cell phone and the fact that his analysis says it was in Pullman, Washington, and not Moscow on the night of the murders. The defense plans to use Ray to back up Bryan Kohberger's alibi, that he was out hiking and or running and looking at the stars. So where is this cast report?
We're happy to, and when we get the cast report, we'll disclose it. If we do not have it, we are not reporting it. As simple as that.
I read that last night. Okay.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand, and I understand your frustration, and it's a big deal. It's really
It is a big
important. I understand that too, and I acknowledge that. Sometimes, we just can't quite get what we want from other people who might have it that don't want to give it up. So that's one of my challenges on the 14th.
So there is something that both Judge and Taylor consider to be a big deal, but they're dancing around it in public. They won't come out and say exactly what it is. But things have become a little too tense between the defense and the prosecution for Judge's liking. Take a listen.
I trust both of you, okay? Your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. It started at the last hearing, and I really want y'all to just tone it down a little bit. I mean, you can argue all you want, but when it starts to be personal, it's destructive. I mean, you're really, really good lawyers. So let's just focus on the issues.
So this is the second time just recently that Judge has told both sides to basically chill out.
I do, for the record, need to clarify the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on, instead of being patient and wait, because our discovery deadline isn't until September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas duces tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules.
So Judge said he will seal that upcoming hearing on May 14th, where this motion to compel discovery will be heard. And he said there could be a portion of that hearing that could be open to the public. He'll just have to wait and see. He's also going to sign some subpoenas for the FBI to try to get this information that the defense wants. And remember that alibi information that Bryan Kohberger submitted to the court? Well, the state is asking Judge to reject that information. They're saying they've been prejudiced and haven't had an ability to investigate it properly because it's not specific enough. And if Bryan Kohberger wants to offer an alibi, the prosecution said the only reason he should be able to is if he takes the stand, because he doesn't have anybody who can say he was anywhere else but the scene of the murders that night. Here's what former prosecutor Andy Wilson said about Kohberger's alibi information when we spoke about it recently.
Well, first of all, the Idaho Criminal Code requires that if you're going to use an alibi defense, you have to file notice of it. This is part of that process. And the whole idea is to put the prosecution really kind of on notice of what it is you're going to try to say, so they can prepare to present rebuttal evidence to deal with whatever that defense is going to be. So typically, from a prosecution point of view, what you like to see with an alibi or with a notice of alibi is some level of specificity. And what I see here is this is just kind of a general pleading. Hey, the defendant was out in the country in the middle of the night, looking at the moon, looking at stars. From a prosecutor point of view, I certainly would respond and ask for more specificity. I would ask for specific witnesses who may be able to prove his comings and goings. They did list a witness that they're going to try to use to show where he was through phone records, but I just don't think that that's probably general enough to do what you have to do with respect to the alibi.
Yeah, I mean, I think they're going to want a specific person who can actually testify to this. That's what I'm guessing they mean by a witness, a person that can put you there. I'm also here seeing that they say he was at this favorite spot of his. It's Hawaii Park, and that this became a favorite spot of his as he moved from Pennsylvania to Washington in June of 2022. This is somewhere he frequented. He was a night owl, so he would frequently go on these drives, and he actually had photos, including in November of 2022, at the same month of the murders, of the sky and of the moon and the stars. So this guy's out and about at night, late at night, in the early morning hours, according to the defense, taking pictures of the stars and the moon at this park. So does that help him that this is somebody who is out and about at times in the middle of the night?
So I don't think it does. Again, it doesn't provide enough specificity to actually prove that he was somewhere else at the time of the murders. As a matter of fact, when I prosecute cases, I like the notice of an alibi because it kind of tips the defense hands. It kind of shows me what they may or may not do with respect to the case. And there's a couple different things I look for. Number one is you can get a notice of alibi that shows that your defense is going to be, you're just going to throw anything you can against the wall. So, and again, that's kind of what you see here. It's just kind of an absurd story. This guy likes to just go out in the middle of the night and take pictures of the moon and the sky. And look, I'm not saying he does that, but you also have to deal with the fact that his DNA's in the scene. You've got to deal with the fact that he drives the exact same car that we know is over in the area of the murders. And just to say that he was out, the exact same night of the murders, and he's out just driving around the countryside is just absurd. The other thing that I look for with respect to a notice of alibi is a lot of times it can kind of indicate whether or not the defendant's ultimately going to testify in the case. Because I've seen alibi notices where, look, the only way this alibi is going to be able to put forward is if the defendant takes a stand. And what you're seeing here is they put this expert that they're going to try to use to show the phone records. That indicates to me that, again, I don't think this defendant's going to testify.
Kohberger maintains he did not murder Maddie Mogan, Kayla Gonsalves, Ethan Chapin, and Xana Kernodle in the house on King Road on November 13th of 2022. So we will keep an eye on all of this and keep you up to speed on the latest developments. That's it for this edition of Crime Fix. I'm Angenette Levy. Thanks so much for being with us. We'll see you back here next time.